domestic battery charge in Indiana can have lasting consequences affecting a person's freedom, their family, and even their future. Understanding what a domestic battery is, along with having the right lawyer, is absolutely critical. So let's talk about domestic battery. Domestic battery is the second most commonly charged crime in the state of Indiana. It is something that we deal with as a law firm every single day. And from my experience, not to say domestic battery is not a very real problem, but it's often one of the most abused forms of criminal charges because a police officer typically does not witness domestic battery. It's somebody calling, hey, I'm being a victim or I've been hurt. And there's usually not direct witnesses. There's usually a time difference between the charges are filed and when it actually occurred. So there's all sorts of just my problem that's ripe for abuse. And I do see that abuse on a consistent basis. So let's talk about domestic battery different than a regular battery. Well, a domestic battery is a regular battery plus the addition of a family or household member. So domestic battery states that the alleged victim, in legal speak, in my world, is a family or household member. So that's basically anybody who shares an intimate relationship, even if the intimate relationship is over. An ex, child in common. We haven't been dating in years. It could actually be mother, son, father, daughter. Relation by blood, relation by marriage. But there's a very broad net for family or household member that turns a regular battery into a domestic battery. So keep that in mind. And in my experience, courts are more than welcome to be over-inclusive with this family or household member as opposed to exclusive. That being said, domestic battery is a regular battery plus family or household member. What is a battery? Battery is very simple. It's a rude, angry, or insolent touching of another person. There you go. That's a battery. Maybe it's not rude to me, but it's a touching of another person in a rude, insolent, or angry manner. And so when that touching occurs, when the aggressor touches a family or household member, it's a domestic battery and it starts off as an A misdemeanor, 1 year in jail, $5,000 fine. Now, a domestic battery jumps to a level 6 felony in a couple of different ways. The first one is if the person being accused of domestic battery has a prior unrelated domestic battery conviction. It doesn't matter if it's the same person that's alleged to be the victim. If they simply have a prior conviction, then the next domestic battery is a level 6 felony. Those charges get filed a lot. But the more common felony domestic battery that we see is if and when the domestic battery occurs in the presence of a child. And so a child is considered anyone under the age of 16. And presence is a very broad category. People will be like, well, Mark, the kids weren't there. They're actually upstairs asleep. Doesn't matter. That's present for the most part. The kids were in the other room. They're present for the most part. They were napping. They're present for the most part. It's very, very easy for a felony domestic battery to be charged if kids are basically anywhere in the vicinity. So keep that in mind. And felonies, it's not fun. And seeing that felony on there obviously makes people panic because felony has long-lasting consequences on a person's job prospects, licensing prospects, freedom. The jail time goes up significantly. A level 6 felony, 2.5 years in jail, $10,000 fine. So no one wants to be charged with felony, and we will fight every step of the way. But just understand it's very easy for a domestic battery to be charged as a level 6 felony. And domestic battery can also be charged as a level 5 felony, 6 years in jail, $10,000 fine, if the person is alleged to have committed the battery against a pregnant individual, if there is serious bodily injury, if there's a weapon involved, or if the alleged victim is the same victim of a prior domestic battery conviction. So there's other ways that can be a level 4 felony, even level 3 felony. We're not going to talk about every single way, but domestic battery is never good, and domestic battery as a felony is even worse. So with the domestic battery, immediately when a person is arrested for domestic battery, there's going to be an automatic no contact order. So if that person gets out of jail, they cannot have contact with the alleged victim, and that's going to be an automatic no contact order. Now, when a person goes to court, that expires, and then the prosecutor actually raises his hand like, hey, we want another no contact order, and that no contact order will last through the length of the case, possibly longer. The person's on probation, incarcerated, or home detention. But that's an automatic no contact order along with a regular no contact order, and the no contact order is a one-way street. So the person that has a no contact order can't contact the person who the no contact order is against, but the alleged victim can send messages and whatnot. And it's infuriating because people are like, I feel like they're setting me up. I love you. I miss you. I need money for groceries. Come pick up your kids. And the person can't respond. And they're in this catch-22, and it's terrible because people get arrested and they still love their family and they can't be with them. They can't go around them. Domestic battery is one of these heart-wrenching crimes, especially in situations where we believe it's being abused for whatever reason. So domestic battery stinks. And if a person violates the no contact order, two things can happen and will happen if they violate. Number one, it's going to be a new crime called invasion of privacy. Invasion of privacy, the first one, a misdemeanor, $5,000 fine, 1 year in jail. But more problematic is if you get charged with a new crime and you're out on bond for the domestic battery, getting charged with a new crime violates the conditions of release or the being released on domestic battery. So a person ends up back in jail, and it stinks. Because being in jail, you have a negative bargaining position. Prosecutors love it. Because they, hey, a person's going to take whatever plea I give them. Hey, sign this right here. But the people that are innocent, people that can't be found guilty, people that are fighting for their innocence, fighting for their livelihood, fighting for their future, fighting for their family, they're in a terrible spot. Because now they're in jail for a violation, and they have a terrible choice. They can sign a plea, get out immediately or pretty quickly, but have all sorts of conditions on their freedom, or they can ask for a fast and speedy that the court can give them within 70 days. No one wants to be in jail. So this is truly terrible when someone ends up violating the no contact order and they end up in jail for their domestic battery case to be resolved. And then people ask me all the time, I actually get alleged victims calling me constantly, hey Mark, I'm the alleged victim in your client's case. I don't want the no contact order. Let's file for a motion. Let's get rid of that. It's not up to me. It's not up to the alleged victim. It's up to the judge and the prosecutor. For lots of reasons, prosecutors do not like getting rid of no contact orders. I'm not saying they don't do it, but they don't like it. And then even more so, depending on the county, depending on the judge, depending on the charges, judges will not get rid of no contact orders, even if the prosecutor is okay with it. So it's not as simple as raising your hand and saying, I don't want no contact order anymore. Once that train leaves the station, well, it's en route, and we'll have to deal with that. But it's not as easy as simply saying, I don't want no contact order. That's not saying we do not get no contact order dropped all the time, but it's not as easy as some people make it believe. Another little fun fact about domestic battery, when a person is arrested for domestic battery, they're going to be in jail for 24 hours. Even if the evidence is weak, they're going to be in jail for 24 hours. It's a cooling off period that the Indiana legislature has instituted. So even if a person gets a bond immediately, $1,000, $10,000, $5,000, they can pay that bond. They still are not going to get out for a full 24 hours. Now, in some counties like Marion County, where things move a little bit slow, that may not be the biggest of deal, but other counties move a lot faster than that, and sometimes even Marion County moves faster than that. But a person can't get released until it's been 24 hours. Now, people ask all the time, well, Mark, this sounds pretty serious. How do we fight a domestic battery charge? Well, that's where I come in. Me and my team fight domestic battery charges all the time. Like I said before, there's usually not a police officer witness. I have had one trial where there was a police officer witness. It's happened to be walking down the street. But usually there's not a police officer witness. So a domestic battery case is typically he said, she said. And oftentimes people will be like, well, Mark, I'm going to believe the person that the officer charged because, officer was the first on scene. Officer probably knows. I'm going to tell you a little secret. Police officers will arrest a person for domestic battery on a very, very, very low evidence. And they do this because every single officer is terrified of them getting to a scene, being like, nothing, you guys are just overreacting, and then leaving, and then something bad happening to the alleged victim. Many police officers take the stance, I'm going to arrest the person who I think maybe is involved, or the person who's not crying, whoever, I'm going to arrest the person that called 911. I'm going to arrest the one that didn't call the police. I'm going to arrest the male every single time because that person's physically bigger than the female. Sometimes vice versa. But officers will make these arrests even on very low evidence. And sometimes officers leave breadcrumbs in the probable cause affidavit. Oh, visible injuries. That's a pretty big one. Injuries looked old. I'm unsure what exactly happened, but I have no reason to disbelieve the person that called the police. Officers will arrest on very low evidence, but the good officers will leave breadcrumbs. Now, I'm not agreeing that officers should arrest on low evidence, but they don't want to be in the paper for the person that showed up to a domestic violence and they left and something bad happened to the alleged victim. So you will see more often than not, domestic violence call, an officer is going to make an arrest. So it's not enough to be like, well, the officer arrested that person. They're probably guilty. That's not enough. So for domestic battery, self-defense still applies. And we see this a lot with men who basically their partners are pushing them, and then the man finally has enough, pushes back, leave me alone, and the partner just loses their mind. You hit me, I can't believe you hit me, even though that same person was hitting the man for the last half hour. And this goes to women too, back and forth. We've seen men go after women, poking. Women finally pushes back, and all hell breaks loose. We've also seen same-sex couples, same exact scenario. There's one person that's a little more aggressive in the relationship, and then when the other person finally has had enough and pushes back or tries to defend themselves, oh my God, you hit me, I can't believe this, and they call the police. It's the victim mentality. Now, I'm not saying domestic battery is not real, but I do believe it's one of the more abused charges in the state of Indiana. So self-defense. We also have bias. It's he said, she said. People will make claims for domestic battery for all sorts of reasons. Some people just want that 24 hours so they can move out without their partner being in their business. Some people want to charge domestic battery so they can get a better position in their family law case, because if you're convicted of domestic battery and you are presumed to not get the same parenting rights as a person not convicted of domestic battery. There's all sorts of nuances why people would lie about domestic battery, and so we get to argue that. It's called bias, and there's almost no limitation that the courts can put when arguing bias of a witness. And we also argue lack of evidence. This is where we come in, and the officer's like, hey, there was no physical evidence, but I'm going to arrest this person. So if there's domestic battery, and now people can hit each other and without leaving marks, and people do that all the time, but we can also argue lack of evidence, such as bruising, redness, shows lack of battery, and we're allowed to do that as well. And so one of the last things I want to talk about is if a person is convicted of domestic battery. Domestic battery is a crime of domestic violence. Domestic violence eliminates a person's ability to legally own a firearm. And so if you're thinking, well, I don't even need to have a license in Indiana, Mark, so I don't need a license, I can still own a firearm. And yeah, you can go possibly have one on you, but it's going to be illegal for you to have. And if they get caught with that, it's going to be a crime. You're also prevented under federal law from having a firearm. And I tell you what, Indiana criminal law is pretty tough. Federal law is much harder. I would not risk anything like that with a domestic battery, domestic violence, anything like that, having a firearm, because it's going to create a cascading level of errors. Now, if you've been convicted of a domestic violence charge, such as domestic battery, there is a way to restore firearm rights. And it's a complicated process, not the easiest thing in the world, but it happens. We do that at this law firm. So keep understand, a conviction will eliminate the ability of a person to own a firearm. And then there are some really crazy rules regarding turning a felony domestic battery into a misdemeanor domestic battery. Basically, the law says you can't do it in some circumstances, almost all circumstances. So you want to do everything possible to not be convicted of domestic battery, but even more so, felony domestic battery. And so it's worth fighting. Trust me on that. If you have any questions about domestic battery, give me a call, 317-632-3642. We deal with domestic battery charges on every single day of the week. And we talk to people who are dealing with this. And we understand this is one of the hardest things people to deal with because it affects their family. And I understand that. Give us a call, 317-632-3642. Remember to always plead the fifth.